Welcome to all of you in this special session of Criminal Procedure Code. But before that, I would like to discuss a few things about the topic Uniform Civil Code. Okay, what exactly is Uniform Civil Code? We have already discussed, many people have given presentations. I will just come with some new points. Okay, same civil laws for everybody, irrespective of religion, caste, creed, color. This is called Uniform Civil Code, given in Article 44, Directive Principle, Part 4, not justiciable. Where is it written? Article 37 of Constitution says that directive principles are not justiciable. You cannot get it enforced by court of law. It means it is legislature to see when to make laws, or through precedents, judiciary can also make laws, but you cannot get it enforced as a matter of right. Clear? So, why this topic is relevant today? Sometime back, what happened? Just listen to the story. There was a Meena couple. Meena is a scheduled tribe in Rajasthan. Husband and wife, they were not happy with each other, and the husband approached the court for divorce. They were married under Hindu Marriage Act 1955, which allows divorce under Section 13. The wife said, I am not ready for divorce because I am a tribal. And in Meena community, ST, we are scheduled tribals. She said, in Meena community, this is our right not to be divorced. Divorce is not possible in tribals, in Meenas. Okay? So, even Hindu Marriage Act says that when there is a conflict between the rights of tribals, means their own rights, their personal rights, their special rights, and Hindu law, then tribal rights will prevail. Okay? Hindu Marriage Act is not applicable to tribals if there is a conflict. So, due to this, only due to this, the lower court disallowed the petition. And they said divorce is not possible. Then the matter went to the High Court level. Then it began, because marriage took place in Delhi, so they went to Delhi, and Delhi High Court looked into the matter. It was a very good case of divorce. Divorce should have been allowed, but according to the local customs of tribals, it is not allowed. So Delhi High Court sent a notice to Law Ministry. You should come with the law of Uniform Civil Code as soon as possible. Supreme Court also in 2015 gave directions to Union government to implement Uniform Civil Code in India. From where? Listen properly. From where did this controversy start? It started from 1835. 1835, when Britishers were ruling India. At that time, the British government advocated that there should be one law for whole of the country. One law, one nation. Yeah, one nation, one law. This is the concept given by Narendra Modi, the Prime Minister of India. So, framers of law they were confronted with this debate whether or not to implement Uniform Civil Code. Dr. B.R. Ambedkar also was satisfied on this point. Yes, we should move in the line of Uniform Civil Code, but it should not be made mandatory. It should not be made applicable with force. Okay. So not only this, there are many other aspects, especially political in nature. When from the independence of India also, it was in limelight. There are some historical aspects. 1835, British government advocated Uniform Civil Code in India. 1931, a committee was formed by British government under the chairmanship of Shri B.N. Rao, the legal expert and the legal advisor, the constitutional advisor of the Constituent Assembly. Okay, who later on became the constitutional advisor of Constituent Assembly. Shri B.N. Rao headed the committee to make law on Uniform Civil Code in 1931. Okay. Then the process was going on, not 1931, it was 1941 when the Second World War was going on. Okay. But after Second World War, UNO was formed and India got independence, due to which B.N. Rao committee report on Uniform Civil Code could not get a final shape. Then Shri B.N. Rao, he became the constitutional advisor, and then after independence again, he started working on Uniform Civil Code. It was B.N. Rao only who got Article 44 drafted and got it placed in Part 4 of the Constitution of India. Okay, then B.N. Rao then started working on Uniform Civil Code after independence of India, and then he came up in 1955 with the famous Hindu Code Bill. Pandit Jawaharlal Nehru was very zealous, enthusiastic to implement Hindu Code Bill, same laws, same civil laws to everybody in the territory of India. But due to opposition from the side of Sangh Parivar, okay, RSS and many others Hindu nationalists, they said we are not ready for Hindu Code Bill, due to which Hindu Code Bill could not be passed in one go. It was passed in 4 parts: Hindu Marriage Act, Hindu Succession Act, Hindu Adoption and Maintenance Act, and Hindu Minority and Guardianship Act. Then what happened? Judiciary started working on this project. Okay. And what happened? There was a case of Shah Banu. For the very first time, a Muslim lady, 60 years of age, having 5 children, she was when divorced by her husband. She went to the court and claimed maintenance under Section 125 of Criminal Procedure Code. She was given maintenance, stating that CRPC is a secular law equally applicable for everybody in India. Listen, 1984, death of Indira Gandhi. 1984, elections were held and Rajiv Gandhi became the prime minister with a big margin because he got sympathy vote. Okay, 1984 and 1985, what happened? Shah Banu case. All the Islamic dharm gurus, okay, all the Islamic fundamentalists, they opposed Rajiv Gandhi government that for inaction by Rajiv Gandhi government. They started protests and processions, dharnas, in order to appease, means to make them happy. Appeasement ki rajniti, tushti-karan ki rajniti, this started. In order to make them happy, Rajiv Gandhi in 1986 came with a very infamous law, Rights of Muslim Women on Divorce Act. This was a bad law. Supreme Court gave maintenance right to Muslim women also, that beyond iddat period also they can claim the maintenance. But again, the old position was restored by this law by Rajiv Gandhi. Then again, Supreme Court in Daniel Latifi case restored the maintenance rights of Muslim women. Due to this, many Hindu community people went on roads. They came on roads against Rajiv Gandhi government. Rajiv Gandhi, who was treated as a modern PM, a young PM with a new approach, with an innovative and creative approach, who started using computers and information technology in governance. Okay. And that Rajiv Gandhi was criticized by all Hindu nationalists. 1986 to 1989, it was like a black spot on politics by Congress party. Everybody said, Congress Muslims ki hai. Congress always favored Muslims, maybe right way or the wrong way. Okay, because by a wrong way, Rajiv Gandhi supported Islamic Front. Okay, then what happened? A big thing. 1989. What happened in 1989? Rajiv Gandhi started appeasing Hindus. He ordered Hindus have right to worship Just like in a temple, they have right to worship in Babri Masjid. He ordered break the locks. Look, he has to take care of his vote bank. 1984 plus 5 means 1989. He was very much worried of his vote bank in 1989 elections. In order to win elections, Babri Masjid dispute started. Okay, and in 1991, 1992, BJP came there and said, Mandir wahi banayenge, Ram Lala hum aayenge, Mandir wahi banayenge. And Babri Masjid was demolished. Then army interfered, and then Supreme Court interfered, and just now, what happened? In 2014, Prime Minister Modi came in power, okay, with 3 declarations. I will abolish special status of Jammu Kashmir. I will abolish Article 370. 3 promises were made. First, the 370 abolition. Second, construction of Ram Janmabhoomi Mandir. And third was bringing uniform civil code. 2 promises already over. After Modi came to power, Supreme Court decided that instead of Babri Masjid, there should be Ram Janmabhoomi Mandir. Mission accomplished. Article 370 was abolished. Mission accomplished. Just 1 promise more out of the 3 promises made by Modi government is still pending, and that is uniform civil. Then Modi very well knows this cannot be done in one sweep. It has to be done in parts. Then what he did? He imposed a ban on triple talaq. Okay, you very well know Saira Bano case. Okay, Saira Bano case, he imposed a ban. And what happened? Ashwini Upadhyay, a BJP leader, he too has gone to court saying there is no right to convert. Okay, and recently, just 3 days back, Delhi High Court gave a verdict. There is no fundamental right to convert, and conversion through fraud, conversion through allurement is banned. Okay, moreover, these were some points, okay, about the historical aspects of Uniform Civil Code and politics, all about it. There are many people who oppose Uniform Civil Code, especially Asaduddin Owaisi. Yesterday, I sent you a YouTube video also. You saw that? A news channel video? You got that on WhatsApp? Yes. You watched the video? You should have. He says, the only state in India having Uniform Civil Code is Goa. And you know, in Goa, what's the rule? Anybody who doesn't has a son and the wife reaches the age of approximately 25 or 30, that person has a right to marry the second time. Hindu can marry once again if there is no son. This is the rule in Goa. Asaduddin Owaisi said, why only you target Muslims? If you want to bring about Uniform Civil Code, why don't you apply it on Hindus? Why don't in Goa, just like in Goa, why don't you allow all Hindus to marry second time? Just like a Muslim can marry 4 times now. Okay. Or you change the law in Goa. Either you change the law in Goa or make Goa law applicable to all Hindus. When you are discriminating between Hindus of Goa versus Hindus of all other states, then why not let it be the situation going on as it is? Let Muslims marry 4 times. Okay. Then there are many other such laws. Northeastern states, they have their own culture. One female can marry many men. Okay. So we allow that. Still, this is legal. In Mizoram, in Nagaland, it's allowed. Asaduddin Owaisi said, are you ready to impose a ban on that? Can you take a panga? If you take panga, they will go to China. They will start supporting China. You will lose Arunachal Pradesh. But you are silent on that. When you are silent for Northeastern people, why aren't you silent for Muslims? One more, because look, we must not be biased. We are people of law. Okay, we should see the thing from both sides. Okay, we then, which are the things which are very much in limelight in Islam, especially nikah, halala. Do you know what is halala? What is halala? Hand raise. You have to speak in English.
First option is that man can marry another man and you have to divorce with that man. After that, you can decide your husband.
After divorce from the second husband.
After divorce from second husband.
This is nikah halala.
Second. Okay. मेरी friend का भी इस था.
Maybe abroad in India. Are you sure?
इंडिया में करनी है अगर तो मुझे
nikah halala. Oh, okay. Because in many other countries halala is banned, but India there is no ban on halala. What happens if husband and wife they get divorced, okay, and then they want to again come together? After divorce, if the wife wants to marry his old husband again, the wife cannot marry. The wife would have to first go for halala. Means that wife would have to marry some other man, and not only marrying and then divorce, marriage plus sexual intercourse and then divorce, and then only she can marry the old husband. Because sometimes if the man is drunk or something like that, they get divorced. And after about 4 or 5 days, after the cooling down, if they want to again live together, first the wife would have to go for sexual intercourse with somebody else. And why some Islamic fundamentalists are against abolition of halala? Because these are what happened. In practice, it's there. Husband himself takes his divorced wife to somebody, a cleric, means those who sit in masjid, the priests of masjid, Maulanas. They take to Maulana, please marry my divorced wife for 1 day, have sexual intercourse, and then divorce her, and then I will marry. Husbands take their wife for halala. So that's why all the Islamic Dharm Guru, they say halala should be there. Halala is right. They want to maintain halala. And Muta marriage you have heard of? And there is one Mysar or something like that. The name is something like Mysar nikah. Okay, in which for payment of money, you pay money and you get married with a Muslim woman of any age for some time, for a few months. So people from Saudi Arabia and Dubai, they come, they marry women over here in Hyderabad, especially 12 years old girl, 13 years old girl, the girl who has just attained puberty. After puberty, so the girl who has just attained puberty, okay, 12 years, 13 years, they get married to them for 4, 5, 6 months. They live with them and then they go away. This happens in Hyderabad. Okay, so very much we are in need of making same laws for all people, same civil laws for all people. Okay, I have a lot to speak, but I don't think more time should be given to this now. Okay, and moreover, Ovesi says, why only Article 44? There are many other DPSPs. In Part 4, Directive Principles, it is written there should be laws to prohibit intoxicating drinks. Why don't you impose a complete ban on liquor? In the time of Corona, Delhi government took a stern step. Punjab government took a big step to allow sale of alcohol. There was a big row outside all thekas. Because when people are sitting at their home, they should have something to enjoy. Okay. So, moreover, the main thing was the revenue for which this was allowed. Okay. So, why only Uniform Civil Code? Why not other DPSPs? If you are so eager to implement, why only you are eager to implement this DPSP? Why not other DPSPs? So these are some more arguments given by some people who enter into debate over Uniform Civil Code. Fine. With this, I end my